Good afternoon, everybody, or good morning to those of you joining from the west coast of the States. A special hi to Nikki in particular. You're very welcome to this, our Built Environment webinar, focusing today on commercial leases and in particular options open to tenants faced with the prospect of having excess space under the terms of their lease. You're all very welcome, and my name is Jamie Fitzmaurice. I'm a partner in the real estate department here in Mason, Hayes and Curran, and I'm joined this afternoon by my colleague and partner Tom Davy, who also works in the real estate department. I suppose the pandemic is obviously the overarching framework against which today's talk is going to be, I suppose, etched, but I don't want it to be focused solely on that. But I think it's going to be inevitable in many respects. And I think looking at a number of surveys which have come out, it'll purely demonstrate that. Most recently, I think last week, we saw a survey coming out of America which showed that 82% of tech companies there expect to have less need for space in the next 12 to 18 months. And of that, 55% expected to be actively divesting themselves of that space. Closer to home, a recent survey showed that, I suppose, whilst grey space didn't typically make up a large portion of the available office market space in Dublin, that has been changing. And that, I suppose, since 2019, approximately 25% of that space, so of the available space rather, is grey space. And that's important for, I suppose, for incoming tenants looking to avail of good quality space on short-term flexible terms. I'm very conscious today that we have a nice divide between landlords, tenants and agents joining us this afternoon, and conscious that in very many respects you'll be more expert than myself and Tom on many of the topics we're discussing. So do please feel free to put in comments or questions into our chat function at the bottom of the screen below. It'll keep the session interactive, and hopefully we'll get to as many of those as we can at the end of the session. I suppose, Tom, for the purposes of the conversation then, and for this webinar today, we might assume a hypothetical lease, an FRI lease of say 15 or 20 years, an SPV tenant, a special purpose vehicle tenant of, I suppose, little or no substance on paper at least, and for that reason, a guarantor, and say a US multinational guarantoring the tenant's obligations. Faced with the prospect of having excess space, can you just talk us through maybe some of the options that are available at a high level, and then perhaps we might circle back and drill down into each of them in more detail?
Yeah, happy to do that, Jamie. Hi, everyone, and thanks for joining. I think, Jamie, at that high level you mentioned, the options really available to tenants are, check the lease. If there is a break option, consider that and how it might be exercised. If there isn't a break option in the lease, perhaps you could enter into a negotiation with the landlord to do an early surrender, either partial or entire, and again, worth considering. Then looking closely at the lease, I suppose a tenant should consider the options available to it as regards assignment of the lease, subletting of the lease, or indeed a license arrangement, or what's commonly known as kind of sharing of possession. So I suggest there maybe the sort of headline options, and maybe they frame what we're going to have a chat about.
I suppose to be completely hyperbolic for a moment, it's been said that the valid exercise of a break option is the most destructive thing that can happen to the landlord and tenant relationship under a lease, I suppose, because it brings an end to that lease. I suppose from a landlord's perspective, that's probably why any conditions attached to that lease are strictly construed, or certainly a landlord will wish to see strict adherence by the tenant to any conditions attached to the break option. You might just talk us through some typical ones and, I suppose, pitfalls that can arise there.
Yeah, I suppose, look, that's absolutely right, Jamie. A break option is a kind of a fairly nuclear solution, if we can call it that. In that it terminates the relationship between the landlord and the tenant, and given that they're sort of traditionally seen as quite an advantage to a tenant, a landlord will typically insist on very strict conditions being satisfied before a break option can be exercised, and those conditions typically involve the service of a specified notice and by a very much defined deadline. Typically, the payment of a break penalty to the landlord, and again, payment of that at a specified time, and typically compliance with some or even all covenants under the lease in order to validly exercise the break. And it's particularly onerous for tenants, I would suggest, if it has an obligation to comply with all tenant covenants, because it's just so easy for a tenant to slip up and be guilty of a minor breach. And some of the case law coming out of the UK in particular will sort of and does confirm that the compliance with those conditions are strictly construed as against tenants.
I think, Tom, again, it is UK case law, and we should predicate it on that. But two of the, I suppose, more extreme examples that we've seen coming out of the UK have included tenants who have been in compliance with the terms and conditions of their lease. Well, obviously not, but in terms of payment of the rent is paid up to date, but they were in arrears in terms of some interest that was due on that rent, and that was held to be not to be strict compliance. And then we had an instance of a further tenant who was, I suppose, somewhat conscientious and was delivering vacant possession, didn't want to leave keys unattended and held on to the keys. The landlord couldn't get into the property and was held not to be in compliance with the condition of delivering vacant possession. So I think it does go to demonstrate the fear with which some tenants often, quite rightly, approach break options and ensuring compliance with terms.
Yeah, I mean, absolutely right. Another example is the obligation to yield up vacant possession, and what that means, Jamie. It's a very strict definition in legal terms, and it really means every person and everything is out of the premises, and you can well imagine how that could easily be be breached as an obligation if you're at the stage where you are negotiating a break option in a lease. Really, a tenant will be pushing for it to be as unconditional as possible, and conversely, a landlord will be looking for as many conditions to be attaching to that break as possible.
And you mentioned there, Tom, some good practical advice in terms of check what your lease says. But quite often, break options won't be contained in the lease. They could be contained in a side agreement. You might just talk us through, conscious of the rest of this conversation, the implications of that, like why it might be in a side agreement as opposed to in a lease, and the implications of that.
Yeah, a landlord, Jamie, I suppose, if it is willing to allow a tenant a break option, it will sometimes insist on it being personal to the original tenant, so that if there is an assignment, it can no longer be exercised. It effectively falls away. And I suppose from a landlord's point of view, it is maybe consistent with that personal nature, if that is agreed between the parties, that it be in a side letter or side agreement rather than in the lease, which effectively is there for the entire term, if that makes sense.
Yeah, I suppose that's the contractual option open to a tenant in terms of black and white, what's written on paper. Presumably, there's also the option of just knocking on the door of the landlord and trying to negotiate your way out. Yeah,
absolutely. Look, there'll be many people on the webinar today who will be very familiar with certain of those negotiations and will have views as to whether that option is really viable in this market or not. There's no obligation on the landlord to engage in those discussions, but in certain instances, and very much dependent on the circumstances, the position of the landlord, what its plans are for the building, but it may be willing to discuss an early surrender of all or part of the tenant's demise. There could be another tenant in the building looking for more space. The landlord may have a sort of refurb or redevelopment plans, and typically the landlord would have to compensate the landlord for that early surrender, and that in my experience is typically based around the number of years left to run on the lease, what the rent is, and a figure ultimately that might be acceptable to the landlord to let the tenant go early.
I suppose certainly in terms of what's coming across my desk, I probably have 2 of these live at the moment, Tom, and 2 or 3 completed over the course of the last couple of months from working at home. I suppose in the situation we're talking, the money is typically flowing from the tenant to the landlord. It can, in unusual circumstances, I suppose not directly relevant to today's talk, but depending on which way the money is flowing here, there can be stamp duty implications too.
Yeah, that's right, Jim. I mean, typically a tenant would be paying what's called a reverse premium. So that is paying a sum to the landlord to take the property back from it, in effect, and thereby terminate the lease. So in that instance, there is no stamp duty payable. But if the money is moving the other way, there would be stamp duty payable. So if the landlord is paying the tenant to take the interest back, if you know what I mean, so the landlord is kind of buying it back, as it were, from the tenant, then stamp duty is payable, and that would be at the commercial rate of stamp duty, namely 7.5%. So one to bear in mind, and of course stamp duty works on the basis of the higher of the value of the interest moving hands or changing hands, and what is recorded in the deed or document which is recording that surrender.
And so one other thing which I've seen kind of come into sharp focus this year when acting for tenants, and it came up in two instances, was the tenant negotiated the sum of money in return for the surrender, but what wasn't factored in was VAT arising on that. So was the surrender premium, was it VATable? Was the lump sum figure that the tenant agreed inclusive of any VAT arising as a consequence of the transaction, or was it VAT exclusive? And I think it's important to get that right at the heads of terms stage, where there are heads of terms, because it can lead to further negotiation delays and costs if that's not agreed.
Yeah, absolutely, Jamie. And increasingly, if there is a break option in a lease, you tend to see in sort of modern leases very detailed VAT provisions, whereby it may be the case that the tenant is responsible for any sort of VAT liability suffered by the tenant as a result of the early termination, the exercise of that break. And indeed, if a break or early surrender is being negotiated now, there isn't one in the lease, but it's being negotiated, you're absolutely right. Both parties need to consider the VAT implications, and the landlord in particular will want the tenant to pick up the tab if a VAT liability arises.
So both those situations, both the exercise of a contractual break option and the negotiation of a surrender, bring the lease to an end. The rest of the options that I think you outlined see the lease continuing in existence. You might just talk us through maybe, I suppose, the effect of an assignment. I think is the next thing that we should look at.
Yeah, I think that's right, Jamie. And again, you look to the lease as to how you might do this and what conditions attach. But I suppose step back, as you say, what is an assignment? An assignment, it really is in the nature of an absolute transfer of the lease and all tenant obligations under the lease to a new party. And that's typically why a landlord will insist on compliance with pretty strict conditions, because it is effectively a landlord accepting a new tenant in place of the original tenant who is ultimately released from all obligations under that lease. And that's the position at Irish law. In other jurisdictions, it's possible for the original tenant to retain certain obligations akin to the nature of a kind of a guarantor. But in Ireland, it's very much an absolute transfer of all liabilities and a new tenant for the landlord, in effect. And
I know you, Tom, everybody, you love the law. I think to show the extent of how absolute the assignment is, I think the 2009 Act in particular has brought in a deemed, I suppose, provisions into each lease, such that the incoming tenant, irrespective of what the document says, the assignment says, is as a matter of law obliged to pay the rent going forward and to indemnify the outgoing tenant for matters for non-compliance issues going forward. So I think it really is a black and white. This is a drop dead endpoint in terms of the ability of the landlord to pursue the outgoing tenant, and perhaps guarantor after that.
Yeah, that's right. And I suppose it just brings home the nature of an assignment under Irish law. You know, it is, as you touched on there, it's typically covered in great detail in the deed of assignment, but also enshrined in legislation, interestingly, as you say.
What about the effect, Tom, on our hypothetical guarantor here on an assignment?
Yeah, it's a good point, you know, and people sometimes don't think about the position of a guarantor on an assignment. And typically where it's an assignment to a third party, that guarantor of the original tenant's obligations will want to be released too. There isn't an automatic release of the guarantor. So if, you know, the assignor, the original tenant, is sort of not aware of the guarantor's obligations and the fact that it has to be released separately, it could result in an assignment where the guarantor remains liable for the new tenant's obligations. So very much a case, Jamie, that an express release of the guarantor needs to be included in the consent process. And sometimes a landlord, depending on the assignee, the new tenant that is proposed, may require a replacement guarantor to step in. So, you know, this whole process and the consent process may well involve multiple parties, namely, you know, landlord, original tenant, new tenant, and outgoing guarantor and incoming guarantor. So lots of parties involved.
Just touching on consent there, Tom, and we'll come on to it in a bit. Are there circumstances in which landlord consent won't be required? For example, a kind of assignment to group companies I think with my landlord hat on, that's something that I would be reluctant to agree, and most tenants wouldn't push too far for it. I think perhaps the only circumstances where an assignment to a group company might be entertained by a landlord, well, it'd be personal, I suspect, to that tenant and that group of companies, but also perhaps where there was a guarantor on the hook day one, and that guarantor is still a good mark and on the hook at the date of the assignment.
Yeah, I'd agree, Jamie. It'd be unusual to see a tenant concession whereby it can assign without the landlord's consent, given the sort of absolute nature of an assignment, as I mentioned. A possible exception, although I would say relatively rare, even in the case of group companies, as you say, because there's always a risk that while it's assigned to a group company, and that it is a group company with a much lesser financial covenant, which won't suit the landlord at all. And perhaps an exception is the case, as you've outlined there, where a guarantor, which was originally approved by the landlord, remains in place post-assignment.
Yeah, I think I've really only had that for one or two clients where that's ever been accepted, let alone entertained. So I think it would be fair to say, in terms of what's coming across our desks, that would be rare.
Yeah, I'd agree, absolutely, Jim. Yeah.
So we have the two instances, Tom, where the lease comes to an end. We have the third instance where the lease comes to an end for the assignor, but not the assignee, stays in existence. If we move on to looking at subletting then in whole or part, and perhaps that's something we didn't touch on actually in terms of assignments. Assignments, Tom, would typically only be permitted on a whole basis, whereas subletting could be whole or part, but perhaps you might just talk us through that.
Yeah, absolutely. And I mean, if we're, as we are today, talking about tenants with excess space, not maybe tenants that want to get rid of all of their space, then subletting may well be a more viable option, because an assignment of part would be very rare. And a landlord typically won't want its lease and the premises demised under that lease sort of split out by way of an assignment of part. A sublease operates very differently to an assignment in that it sits under the lease between the landlord and the tenant. There's a separate lease then between the subtenant and the tenant, without wanting to confuse people. It doesn't really affect the head lease at all, and it just so happens that the tenant has a separate arrangement with a subtenant. It does very much require landlord's consent again, and a subtenant will sometimes argue that consent should be more readily available from a landlord, given that it is a sublease structure and that the head lease isn't actually changing.
But you're going to go into the law here again, Tom, and tell us why that mightn't necessarily be the case, I think, from a landlord's perspective, why the landlord might care about the financial covenant.
Yeah, exactly, yeah, Jamie. I suppose, a landlord's going to be concerned here in consenting to a sublease. Basically, it will want a subtenant of reasonable strength, financial and otherwise suitable, because there is a risk if the head lease is terminated early, whether by forfeiture or otherwise, that the subtenant becomes a direct tenant of the landlord. And that's sort of prescribed in Irish landlord and tenant legislation. And does happen reasonably regularly. And I suppose in a market where insolvencies are perhaps more common these days, I think a landlord will maybe be a little more alert to that even than usual.
So that's probably a very good reason why, from the tenant's perspective and the landlord's perspective, that the terms of the sublease mirror insofar as possible the terms of the lease, irrespective of how much the underlying sublessee might want to negotiate. From the tenant's perspective, in terms of ensuring their own obligations are backed to back insofar as possible, it's a good idea to try to mirror it. And from the landlord's perspective, I suppose it's a good idea to have it as close as possible to the position they're acceptable with, accepting of, in the event of that the intermediate tenant goes away for whatever reason.
Yeah, exactly right. And oftentimes, Jamie, the head lease will say that any sublease must be in the same terms as the head lease, right? And that can be quite difficult. If you go back to our kind of hypothetical example, where I think you said a 15-year term, which will inevitably contain fairly strict repair and dilapidations obligations for the tenant under the head lease, as it were, it's going to be difficult to seek to include the same provisions and obligations for a subtenant when it might only be taking a sublease of 3, 4, 5 years, so that's a matter of negotiation really as part of the consent process with the head landlord.
And one of the things, Tom, if I'm acting for a landlord, one of the many things I suppose that I'll be looking at is I want to ensure that the subtenant, almost irrespective of what the tenant has done, I want to see that it's subtenant or subtenants, depending on how many subleases are permitted, don't acquire or can't acquire, perhaps shouldn't acquire statutory rights.
Yeah, I think, look, that's one of the key points for landlords. If they are willing to consent to a sublease, they will typically require that the subtenant execute a deed of renunciation or a waiver of statutory renewal rights, which would ordinarily accrue to any tenant occupying a commercial premises under a lease after 5 years. So very, very important. It's worth sort of rewinding maybe to an assignment. In the case of an assignment, it's maybe less common where a landlord will insist on a deed of renunciation, but it probably would if the original tenant, which is seeking to assign the lease, executed a renunciation, and the landlord really just wants an equivalent position with the new tenant. But very common in the case of subleases, as I say, typically required by landlords.
And again, subleases, much like assignments, conditional upon consent. What about, I suppose, more informal arrangements, group sharing, licensing? There are obviously options that will, to an extent, be open to tenants as well.
Yeah, exactly. And it's become, I suppose, maybe, fairly common in recent years for a tenant to have an ability to share space or license space within the demise to its group companies without the consent of the landlord. Now, the tenant will typically have to indemnify the landlord for any statutory rights that might accrue to those third-party group companies, it will typically be limited to group companies only, Jamie. It suits a lot of group companies with different and varied operations, and rather than having to go through a formal process with the landlord, it can allow another group company, typically temporarily, to use some of the office space and share that space with the tenant.
And then, Tom, in terms of documenting the consent, you outlined the number of parties. You could have a tripartite agreement, as you outlined, or you could have 5 parties. I'll leave it to you to tell me what the equivalent of that is in terms of 5 parties. That's going to form take the form of a license to sublet or license to assign. You might talk us through the reasons for that. Often we're asked, why can't we just do it informally, or can it be done informally? I suppose there are good reasons, and not just the need for lawyers to get involved reasons.
Yeah. I mean, look, a lease will typically say, as one of the conditions to consenting to either a assignment or a sublease, that the landlord must get an express covenant from the assignee or the subtenant, so directly to the landlord. And the way that is achieved is by way of we'll maybe keep it simple, a tripartite agreement, which is landlord, assignor, or the original tenant, and the assignee, that new tenant, so that the landlord has that direct contractual arrangement and commitment, legal commitment from the new tenant. So there can be no question as to the obligations that new tenant owes. And it can, as you say, be other parties can be involved if there's an outgoing guarantor and an incoming guarantor, and arguably there can be even more parties involved if there is a funder or lender in the background who might be joining in order to confirm its consent, so that all parties can see. So it can be a reasonably complicated process with multiple different parties involved. Ultimately, the landlord will have the say in terms of its consent, but typically the lease will require the landlord not to unreasonably withhold that consent.
And in terms of with my landlord hat on, Tom, who's paying for all these legal advisors? The landlord has put the lease in place, doesn't really want to get involved in this. Who pays for the landlord's legal fees?
Yeah, again, Jamie, typically a requirement in a lease that the tenant which is proposing to assign or grant a sublease covers the legal and other costs incurred by the landlord in assessing the consent application. And sort of much to the annoyance of certain tenants, that's typically irrespective of whether the consent issues or not. Because really the landlord position will be, you know, look, as you've said, Jamie, you know, why am I going to the trouble of this, incurring costs and lawyers and accountants and maybe tax advisors and so on to consider all of this? They'll want to be paid and insist on being paid typically before the consent issues, if it is going to issue. And it's worth saying, I suppose, Jamie, both generally and in terms of the cost side of things, there's a legislative provision in the Landlord and Tenant Acts, section 66 of the 19th, which also, irrespective of what it says in a lease, requires the landlord, you know, not to unreasonably withhold its consent, and deems it reasonable for the landlord to insist that its costs are paid. So not only is it recorded in the lease, but again, there's a statutory basis for a landlord to recover its costs in those circumstances.
And again, I suppose, in terms of a landlord trying to protect itself, either because it should or because it's being asked to by a bank, where we're not happy with the covenant of that Irish tenant coming in, say, or even if it is a foreign tenant coming in, we're going to look for a foreign lawyer's legal opinion. I suppose that's something that I think most tenants mightn't be altogether surprised with, but it's the cost and time frame that mightn't have been factored in, and that sometimes causes surprise.
Yeah, look, it's a fairly standard requirement. It's sometimes confused with, you know, a sort of a confirmation as to financial strength. It's nothing to do with finances, because you are faced with, or the landlord is faced with, a non-Irish tenant or indeed guarantor. It will need a legal opinion from a law firm in the country of incorporation of that entity to confirm that it can, in effect, you know, it has the capacity and authority to execute and be bound by the arrangements and agreements it's entering into.
So we've talked about the need to get consent. Like, when you're acting for a tenant who's looking to assign or sublet, and you're looking to pull together, I suppose, a detailed pack to give to the landlord, what typically are you going to recommend is pulled together quickly, and leaving aside what a well-drafted lease will quite likely provide for in any event?
Yeah, well, look, as you say, the leases tend to be pretty detailed as to what the landlord requires in order to even consider a consent application, Jamie. And look, I suppose, while it's by no means the only factor, the key factor typically is the sort of financial test of the proposed assignee or subtenant, and whether that meets the landlord's sort of reasonable standards. If that test sort of can't be satisfied, the landlord may well come back and say that it requires, you know, security or further comfort from the subtenant or assignee, and that can be in the nature of a guarantee, as we've kind of touched on earlier, a rent deposit, a letter of credit, or and so on. And it may be the case that you know, the tenant, or rather the assignee or subtenant, is not in a position to satisfy the financial test now, but it may well be in a position to do so in a number of years. So those sort of additional security requirements often fall away when the tenant is able to satisfy that test.
What kind of test are you talking about there, Tom?
Yeah, the financial test, I suppose. Look, traditionally, there is a test, institutional test based around the proposed assignee, or indeed tenant on the creation of a lease, but assignee or subtenant providing 3 years audited accounts showing net profits in excess of a multiple of 3 times the annual rent, service charge, and other sums payable under the lease. Now, that's by no means definitive, and it has kind of changed over time, and it changes certainly from landlord to landlord, and certain institutional landlords will want a multiple higher than 3 times. And look, challenges are encountered sometimes with, you know, technology companies, it's an issue we've encountered previously where, the Irish SPV that they are proposing as the tenant, again, to touch back on your example, Jamie, at the outset, certainly won't have 3 years audited accounts, right? And even the parent company that it's offering as guarantor may not have, the equivalent of 3 years standing, because it has just been so successful and has hit a sort of a very strong valuation within a very quick period. So landlords have had to be sort of, while being very careful, they probably had to be a little bit sort of creative and think outside the box in terms of those valuations and assessing the financial strength of the proposed tenant, subtenant, or assignee.
And then in addition to that, Tom, I suppose if I'm a landlord looking at what's being offered to me, and I suppose a landlord's also going to be concerned about the effect that the tenant or the rent passing under the sublease will have on the value of the building, the value of the underlying asset. So, like, many leases are going to restrict or prohibit a tenant from underletting either at a lower value or consequent upon a premium being paid to take the lease. That's going to cause in terms of getting your sublease away.
Yeah, exactly, Jamie. I mean, a lease will often have a restriction on subleases beyond just obtaining consent, that any rent, or rather any sublease, shouldn't be granted with on the basis of a premium, and it should be at a rent not less than the rent passing under the head lease. That's quite an onerous obligation for a tenant, because if the market drops and open market rents fall below what is being paid under the head lease, and it's going to be very difficult for that tenant to get a sublease away. So the compromise position often when negotiating the head lease is that the landlord and tenant agree that any sublease will be at not less than the open market rent, and a landlord in return will typically require that the sublease rents are disregarded for the purposes of rent review under the head lease. So that compromise is often achieved.
And are you seeing much? I know that I'm with one or two exceptions, not seeing deemed consent provisions. So if a landlord, if I'm acting for a landlord and I'm being slow or difficult, or if I'm being unreasonable in terms of the time it's taking me to come back to your consent application, that timeframes which, if not met, deemed consent kicks in.
I think they're pretty rare. I've certainly been, attempted to achieve them with various landlords. I think landlords would be reluctant to agree to that provision, because, and particularly in the case of an assignment, given the sort of outright or absolute nature of it, while a landlord is, prevented from unreasonably delaying or withholding its consent, it typically won't agree to that sort of nuclear solution whereby there's a deemed consent after the expiry of a certain period. So no, in my experience, Jamie. Okay,
so I think, Tom, we in fairness, you more than me have brought us through the options there: the break option, the surrender, assignments, subletting, group sharing, licenses. I suppose it kind of brings us full circle and to my favorite part of these webinars, which is the rapid fire buzz around, where I get to look at some of the questions which have come in here and spring them on you. I'm not sure if you can see them on screen there, but perhaps if you can't, it's more fun for everybody. But the first question jumping out here at me, and maybe we should have touched on it, Tom, was if an assignee or sublessee satisfies the 3 times rent test, does that mean the landlord has to accept them? I suppose there's maybe 2 points there, Tom. I think 3 times isn't necessarily fixed. It's a guide, but I suppose taking the point, if they satisfy that test or a test, does that mean the landlord has to accept them?
No, I think is the short answer, Jamie. Look, there's more to the landlord sort of assessment, typically of the consent application than just the financial information. They'll be, concerned about what the assignee or subtenant proposes to use the property for. Are there works proposed? The reputation of the party that is going in there. And while I appreciate we're looking at the sort of office sector today, in a sort of retail setting, if a landlord of a shopping centre, for example, it has been held reasonable for a landlord to withhold consent to an assignment or sublet to, for example, a hairdresser's where there are too many hairdressers in the shopping centre already, and that's under the principles of good estate management. So look, it's just an example, but there are other factors, and by no means I would suggest once the financial test is satisfied, is a tenant kind of, our subtenant or assignee home unopposed as regards pushing the landlord into a position where it must consent.
I think one thing I've seen, Tom, is that where a test of whatever level is set, that the landlord can't object to the assignee or the sublessee on financial grounds only. So that still preserves the discretion that you mentioned, but gets over one of the homes. But again, I think generally it's a no on that. Where a break option, Tom, is contained in the lease itself, I think we touched on this, and not in a side letter, does this mean that future tenants can avail of the break option rights?
To be honest, it's not definitive by reason of being in the lease or being in a side agreement. While a landlord might prefer it to be in a side agreement, it really depends on whether it specifies either in the lease or the side agreement that it's personal to the original tenant. And if it doesn't specify that, i.e. it's left open, then it's deemed to be transferable. In other words, moving with an assignment and on to the new tenant.
So it could still be contained in the lease, but be expressed as being for the benefit of Tom Davy Limited. And in those circumstances, notwithstanding it's in the lease, Jamie Fitzmaurice Limited wouldn't get the benefit of it.
Absolutely right.
Okay. Actually, this is something that we touched on, Tom, on a previous webinar. I think we're all seeing quite a lot of it actually come across our desks. Rent suspensions, reductions are presumably also another way to work with tenants. What are you seeing in the market here?
Yeah, and look, we touched on this on a recent webinar in a sort of similar format to this. Look, we're seeing sort of landlords voluntarily engage with tenants in an effort to, I suppose, assist tenants to trade through what is, a very difficult situation for a lot of tenants, and really to try and avoid a forfeiture or termination of the lease, or indeed insolvency of the tenant entity in certain cases. There is a code of practice that was issued recently again for commercial rents. It is a voluntary code, very important to say that. But again, it sort of sets out certain parameters and encourages landlords to engage with tenants where possible, to agree rent suspensions, rent concessions and so on a temporary basis. Typically, oftentimes what we're seeing is a landlord might agree to do that in order to keep the tenant trading, and bearing in mind that a landlord might have a difficulty reletting the premises if it doesn't keep the tenant there. But a landlord will also often want something in return. So it might want to introduce a landlord break option, it might want to push out the term or push out a tenant break option, and thereby offering sort of further sort of security on the investment for the landlord. But we're really seeing every sort of combination of all of those, Jamie, I think is fair over the last 6-7 months.
Is there any appetite in the market from landlords to take a surrender of a lease in circumstances where there may only be 2/3 years left to run? Certainly the 2 or 3 which I'm dealing with at the moment have a combination of 2, 3, and in one case 5 years left to run. So I think that there's probably more one for a commercial decision on that rather than a legal one. But certainly I am seeing instances of surrenders being accepted with those level of terms left to run.
Yeah, I'd agree, Jamie. I think really it boils down to the number, and I mean, maybe the landlord's starting point might be the payment of all rents that are due for the remainder of the term, and then maybe the negotiation takes place from that point down, or but I'd imagine that there is a figure that many landlords would accept in return for an early surrender, and maybe particularly in circumstances where there's only a couple of years left.
You touched earlier on foreign legal opinions. Will landlords accept them from internal solicitors? I suppose this is probably someone keen to keep the costs down, Tom, I suspect, and maybe timeframes up.
Yeah, look, it's something we've encountered, and legal opinions can be quite expensive and take some time. So large multinationals with in-house legal teams will often suggest that, look, we'll give a legal opinion from our in-house counsel or general counsel or someone senior in the legal team. From a landlord perspective, I suppose they're not ideal because there's a suspicion always that it might be a little biased. I suppose more importantly, an independent law firm gives a legal opinion with the benefit of professional indemnity insurance in the event that there's an error in it, whereas you wouldn't have that protection where it comes from in-house counsel. So I have seen it accepted. I think from wearing a landlord hat, I would say, I prefer to steer clear of it. Wearing a tenant hat, you might just propose it in an effort, as you say, Jamie, for convenience and maybe keeping costs down.
I think perhaps the last question here, Tom, and in fairness to the person who asked it, and they're coming in as anonymous, I think it's one of the questions that we were suspecting might be asked and hoping perhaps wouldn't, but case law on landlord unreasonably refusing consent, is this a grey area, Tom?
Yeah, I think it's definitely a grey area. We'd all love if there was a definition of what is reasonable and what is unreasonable. I think there is a real spectrum there of things that landlords can do which might amount to being unreasonable. One, I suppose, and the sort of maybe guiding principle perhaps, is that a landlord really can't insist on improving its position in order to consent. So for example, if a landlord said it will only consent to an assignment if the rent is increased, and this is ignoring rent reviews and so on, so it's sort of independently increased in order for it to consent, that would be deemed unreasonable. I've kind of touched on examples around good estate management and so on, where it is reasonable for a landlord to refuse its consent, and not just on the basis of the financial test that we sort of touched on there, Jimmy.
Okay, so definitely a grey area. Unlike my wall, which is not grey, it's actually Chinese whispers, Tom. In case you were wondering, that's the colour. I
was curious. Thanks, Jimmy.
So I think in terms of giving maybe three key takeaways, Tom, from this, aside from picking up the phone to me rather than you in the first instance, hopefully, three key takeaways that you'd recommend for those who are listening here this afternoon.
Yeah, look, I think, and we say it a lot, I think you refer to your lease and review it very, very carefully to see what you can and can't do under the lease, and that's touching back maybe on some of the points we discussed. Is there a break option? Then look, you might consider that. How do we go about doing an assignment? What do we have to provide to get consent for an assignment, a sublet, or sharing of space? So I think, look, that's the first port of call. I'd say the second step is really sort of early engagement with the landlord to try and sound out the landlord to see what the position of the landlord is likely to be as regards any proposed assignment or subletting. Also, obviously, look, that's probably the first step if you're doing something like trying to negotiate an early surrender and that's outside of the lease. Clearly, you want to have a chat with the landlord. But I think I'm conscious of the length of time and the complexity around getting consent can really delay transactions. And I think having that sort of lined up, at least in principle, with a landlord before you do your deal with a subtenant or an assignee, look, is ideal if you can achieve that. Now, people will say, well, look, while we might get it in principle, ultimately it's going to depend entirely on the party that we present to the landlord, i.e. the proposed assignee or subtenant. But I think having the discussion, or at least opening the discussion in advance, is helpful, because typically an assignee or subtenant will only wait around for so long for that consent, and the further advanced you are in it before doing the deal with the third party, the better, I would say. I think that's two.
That's two. Actually, a third one, which actually just jumped out to me, Tom, in terms of break options and I suppose adherence to those break options, and something which comes up is, so occasionally you'll see in those break options conditions which oblige the tenants to hand over the original lease. So I suppose over a period of time that lease can be lost, shredded, whatever could happen to it. So I suppose if that's a condition, ensuring you have your title documents or know where they are, or if you don't know where they are, link in, as you say, with your landlord to try and see if there's something that can be done on that.
Yeah, exactly right. You know, look, it's about checking the conditions attaching to the whatever you want to do under the lease, be it the exercise of a break or an assignment or a sublease. You know, and similarly, I would add, Jamie, on the exercise of a break, just to be really careful around the conditions attaching, and to consider those very early in the process. You know, a tenant would typically have to serve a notice quite early, maybe 6, 9, sometimes 12 months in advance. So it ought to have sufficient time to very carefully consider the obligations it has to comply with, and do its utmost to try and achieve all of those, and engage with the landlord to help it where it can, to give it some comfort that it is complying. No obligation on the part of the landlord, unfortunately, to do that.
Okay, Tom, we're gone a minute over, so we're going to have our events team shouting at us shortly. So I think we might wrap it up there. Thanks very much to everybody for joining us this evening, or just this morning. For those of you on the West Coast of the States in particular, we see you guys. How are you all doing? We would very much appreciate it if you would take the time to fill out the survey which our events team will circulate after this. In particular, if you have any comments or questions or suggestions for future webinars, that would be great. And also, I'm conscious that we didn't get to a couple of the questions there. Either myself or Tom will pick up with you directly afterwards if that's of interest to you. So thanks very much, everybody, and thanks for tuning in.
Thanks all. Bye-bye.